Welcome to today's program titled SJC Mandates, Treble Damages, and All Late Payments of Wages, Changes Employers Need to Make Now. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit questions throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation that will be required on the CLE attendance affirmation form. Please write this code down as it will not be reread and is required for CLE credit. Copies of the webinar recording and materials along with the CLE attendance form will be distributed to attendees in the days following the webinar. On the next slide, you will see a legal disclaimer. At this time, I would like to turn it over to our first speaker for today's program, Barry Miller. Barry, please go ahead.
Thank you, Kate, and thank you to all of you who are joining us today. My name is Barry Miller, and with me is Molly Mooney. We are both wage and hour lawyers in Seyfarth Shaw's Boston office, and we're here to talk to you just very briefly on a discrete but very important subject here today, which relates to a decision that came out of the Massachusetts Supreme Judicial Court on Monday that has what we are characterizing as tectonic impacts on wage payment obligations in the Commonwealth. And you'll notice that even though we didn't communicate about this prior to, both Molly and I have donned our funeral garb for this presentation. I'm going to apologize in advance that what you're going to hear is almost all bad news. And in looking over the notes for this presentation, I very much felt like I was writing a eulogy for somebody I didn't like very much. And a lot of folks who are with us on this webinar have had experience with what I'm now going to call the Old Wage Act over the years. And I think we should take a moment to remember the Old Wage Act. It was crusty, it was malicious, it oftentimes felt vindictive, but the Old Wage Act would usually allow you to avoid its full wrath if you paid everything that somebody claimed to be due before someone started throwing the statute's name around in court. We're going to miss that about the Old Wage Act. The New Wage Act is much more difficult to comply with and comes with much harsher penalties and really no escape valves. So with that intro, I'm going to turn it over to Molly to give us a little bit of a post-mortem on what exactly happened in the court.
Great. Thanks so much, Barry. Next slide, Kate. So before we sort of jump into the meat of the Reuter versus City of Methuen decision, I do want to give a little bit of an overview and an explanation of what Barry just explained. So it's always been the case since the Wage Act was amended in 2008 that there's strict liability for treble damages. However, under the common law and based on a 2003 Superior Court decision, employers had the ability to essentially avoid treble damages for wage violations if they made payment of the alleged owed wages before a complaint was filed. And that's been the legal landscape, as Barry described it, the Old Wage Act that we've been dealing with for 2 decades. But we are now entering a new era, and so now we have the decision in Reuter versus City of Methuen. So a little bit of background about the case. So the plaintiff in that case, Beth Reuter, was convicted of larceny, and the City of Methuen terminated her shortly after she was convicted. And at the time of her termination, they did not pay her her accrued vacation. So that was a Wage Act violation. They paid her unused vacation time 3 weeks after her termination. So that was late. She eventually sends a demand letter asking for triple damages for her accrued vacation. The city does not pay that. They instead pay her the interest that had accrued on her late payment over that 3-week period. She eventually files her lawsuit and the claims go to a bench trial. The lower court in the Methuen case ruled that the city did in fact violate the Wage Act when it paid her wages late, but the wages were paid prior to her filing a complaint in court. And therefore, the only damages she was entitled to was the interest trebled and attorney's fees. Next slide. Now, the trial court's reasoning in the City of Methuen case was based on a long-standing Superior Court decision. This is the 2003 decision in Dobin versus CIO View. And this was written by Justice Gantz, who at the time was a Superior Court justice. And essentially, the facts of that case were pretty similar to the facts of the Reuter versus City of Methuen case. In Dobin, the employer had paid the plaintiff her salary and vacation at her termination late. They'd actually paid her salary late throughout her employment. So there were a number of Wage Act violations in that case, which Justice Gantz did easily find Wage Act liability. But what the substance of the decision was based on was, well, what damages are appropriate here, where there are Wage Act violations, but the plaintiff has been paid everything that she was owed well before she filed her court complaint under the Wage Act. And Justice Gantz looked to the language of the Wage Act itself in fashioning his opinion. And he focused primarily on one provision that states the defendant shall not set up as a defense the payment of wages after the filing of a complaint. So defense in that provision is actually spelled with a C. So it's a very old provision, but he essentially interprets that to mean that when the legislature included that language, they were trying to prevent a situation in which an employee files a Wage Act complaint and then the employer pays whatever is owed as a way to essentially moot the claim and get out of having to pay treble damages. He says that can't be the case. That's clearly what the legislature was trying to prevent by including that language. But also the negative inference from that statement also must be true, that an employer can make payment before a complaint is brought. There's still a Wage Act violation there because the payment is late, but it impacts the amount of damages available, in which case treble damages are not appropriate where the wages have been paid prior to the filing of a complaint. This reasoning was followed by a number of Superior Court and federal court decisions in the years that followed up until now. Next slide, please. So enter the SJC and the Reuter versus City of Methuen decision. So the SJC reversed course on the entire holding of Dobin. And in doing so, it was really focused on the language of the Wage Act. And it looked to two provisions that you can see here on the slide. So the first, that employees can bring an action for lost wages and other benefits. And second, an employee will be awarded treble damages for any lost wages and other benefits. So both of those provisions use the term lost wages. And the SJC recognized that that term created some ambiguity when it came to late wages. So is a payment that's made late, but before a complaint is filed, is that actually a lost wage because it's been paid? That was sort of the argument that the lower courts were using within Dobin and after. And the court dismisses that and says it looked to the purpose of the Wage Act and found that lost wages include late wages. And once the court came to that conclusion, then when you read the treble damages provision, well then, okay, if lost wages include late wages, then treble damages are implied. As the SJC said, the remedy is explicit. So the court really was focused on the legislative purpose of the Wage Act, and it went through the history and decisions interpreting the purpose of the Wage Act, and ultimately said that it imposes strict liability on employers. And it says that employers must suffer the consequences of violating the statute regardless of intent. So that sort of tells you where the SJC was coming from when it wrote this decision. Now, the court really fully rejected the reasoning in Dobin and said that what Justice Gantz did when he interpreted that provision relating to a defense is he drew a negative inference from it. And the court said that it was not going to draw negative inferences, and it was only going to read that provision to mean what it expressly states, which is employers can't make a payment once a complaint is filed and as a way to try to avoid liability or avoid treble damages. And the court includes here an explanation as to really why it made that choice. But it's saying that if we essentially, the court says if we allow late payments to be made before litigation is commenced, it would authorize or even encourage late payments right up to the filing of a complaint. As many, if not most, terminated employees lack the financial or other wherewithal to hire lawyers, it would appear to encourage non-payment as well as late payment. Take of that what you will. I don't think that employers were using this as a way to violate the Wage Act and pay wages late before a complaint was filed, especially because you never know when an employee is going to file a complaint. But that is the reasoning that the court followed, and this is now the decision that we have. Next slide, please. Okay, so now the important part. We're going to talk about the ramifications of this decision and where employers need to go from here. So really what Reuter has done is it's created immediate liability for treble damages for any violation of the Wage Act, even where the violation is corrected and the wages are paid. This is clearly a significant problem. Payroll errors and mistakes happen. Oftentimes there can be delayed direct deposit, a check could get lost in the mail, inadvertent underpayments. These things happen. And Barry's going to talk in a little bit about ways to sort of minimize those types of errors and make sure you have your ducks in a row so that those things don't happen. But employers should be aware now that those types of mistakes and oversights will lead to triple damages. And one additional point before I hand it over to Barry, there's an open question about the retroactivity of this decision, whether it's going to apply to past violations. So the Wage Act has a 3-year statute of limitations. So there's a real possibility here that employers will see claims being brought for past Wage Act violations. And unfortunately, this is particularly the case where employers have remedied violations or paid wages late because obviously the employee is aware of the mistake. And to the extent they know now that they can get double the amount of what they were paid, they will probably seek to do so. So it's an unfortunate situation that we're in, but is the reality of what this decision has created. So I'll hand it over to Barry.
Yeah, before we dig into some of the further ramifications of this decision and what we may be able to do about it, it makes sense to take a step back and think about what the statute itself says. We have not put that in the presentation deck in front of you because it's about this long and wouldn't fit on one slide. It's a statute that first was passed in 1891. It has about a dozen semicolons in 3 very long, rambly sentences. It's very difficult to follow, and it's very antiquated between the 2 sections that make up what we call the Wage Act. But the fundamental command of the statute is to pay all wages that an employee has earned within 6 or sometimes 7, depending on your industry, days after the close of the pay period in which the wages were earned. So that fundamentally is what we're talking about. It's a simple, timely payment of wages statute. And Molly's talked us through the retroactivity piece. There's a couple of specific ways that this interacts with wage payment practices where employers are going to have to make changes. As of a week ago, in terms of a payroll error, when an employer came to us and said, it looks like we made a mistake or there might have been a problem, somebody was paid the wrong amount, what do we do? The advice is very easy. Pay it as quickly as you can so that you don't have a simple administrative issue becoming a treble damages issue in court. And employers had a very strong incentive to make sure that any errors or even potential errors were paid very quickly to avoid the treble damages. And that was especially true where you had something systemic. For example, a payroll error that affected a whole group of people, such that if they filed in court, you'd be looking at treble damages for thousands or tens of thousands or hundreds of thousands of dollars in wages. So the logical course was get to the settlement room as quickly as you can and write a check and liquidate that. Reuter reverses that dynamic. We now have no similar incentive to pay any wages that are due or might be due before an employee gets to court, because it just doesn't matter. What Reuter has said is it's treble damages either way. And it's actually worse than that, because not only has the court taken away the incentive to make a prompt payment, it's actually created a potential penalty for making a payment. Because if you send an amount of money to someone, particularly if they weren't expecting it, for example, in the case of a minor payroll error, what you've done is just hand them an unavoidable claim for 2 times the amount of that payment. So if you're an employer sitting on top of a potential wage violation or even a known wage violation, it may actually now make economic and logical sense to wait for the situation to play out and see if someone files a lawsuit, rather than rushing to cut this check and waiting to see if somebody sues you for the additional 2 times damages. And lest you think that this is a Chicken Little analysis of the statute, the SJC was very cognizant of this dynamic. It's actually mentioned in the decision. And Molly and I, along with our colleague Emily Miller, filed an amicus brief in this case. And one of the points that we made was exactly that the dynamic that the plaintiffs were advocating for would create these sort of perverse incentives not to make these sort of corrections. And the SJC recognized in the opinion the point that we'd made in the brief, and what they said was that that was the arrangement the legislature intended. And with respect to the prompt payment of wages, the legislature had chosen to use the stick instead of the carrot. It's the total analysis. Sort of reading the statute and live with it. It's the full reaction of the court on that point. Related to that consideration, the Reuter decision raises a lot of questions about how to settle an asserted claim where you're dealing with a wage dispute. There is a provision of the statute, a provision of the Wage Act that's called the Special Contracts Provision. And what it says is you cannot waive your rights under the Act, presumably including your rights to collect treble damages, which always clouds any agreement to settle a wage dispute with some uncertainty about the effect of the agreement that you're signing in order to substantiate or invoke that settlement. And now, if you're settling for less than 3 times the amount that the employee claimed to be owed when they showed up on your doorstep, you may be carrying some exposure, such that if you settle for, say, 80 cents on the dollar or even 100 cents on the dollar, the employee may take that amount and go into court and look for whatever's left of the 300 cents on the dollar that the statute provides to them. Now, there's an older case called Crocker versus Townsend Oil that addresses this situation and what you can and cannot waive in terms of a statutory claim under the Wage Act. And essentially, the message of Crocker is that if you are painfully explicit about what the employee is waiving in a settlement agreement, it should stick. So one key takeaway is you need to make sure that in any settlement agreement that compromises a wage dispute in Massachusetts, it is painfully explicit on the fact that you're settling a Wage Act claim and that the amount being paid fully satisfies the employer's obligation to pay multiple damages. And I would even go ahead and get the word treble damages in there so that there can be no mistake about what that agreement does. Another approach that folks may want to consider, because in my view, whether Crocker's good law may be opened up by the Reuter decision. Reuter, as I said in the beginning, is a tectonic impact on Massachusetts wage and hour law. And so there's not too much we want to take for granted going forward. And if folks are at all concerned about the viability of the Crocker decision or whether a specific agreement is going to be sufficient to meet those considerations, another thing you may want to do is parcel out a wage dispute so that what you're providing is characterized as 1x, which is the amount of wages paid to the employee, plus 2x, which is the statutory damages, to fully satisfy any legal entitlement that the employee may have. That's not a simple and easy solution, because once you start characterizing a settlement as including only 1/3 of the amount you're actually going to pay, you may create some incentives by the employee and the employee's lawyer to increase their demands. It may be difficult to settle a claim based on that 1-to-2 allocation, but it's an approach that may be helpful to employers that are really concerned about settling these sorts of claims. So let's go to the next slide. We're now going to talk about some other practical strategies that employers can apply in seeking to navigate the situation that's been created by Reuter. But before we do that, I want to emphasize the gravity of that situation. We now have a situation in which payment of any wage that's owed, even 1 day late, is a violation of the Wage Act. And that much is quite clear. One of the cases that's discussed in the Reuter decision was Claremont versus Monster, which posed exactly that situation, where the employee was fired on, call it a Thursday, the employer deposited his final wages by direct deposit, and he asserted a claim under the Wage Act because the money didn't hit his account through the ACH process until the next day. And for that, he wanted treble damages. In explicitly reversing the Claremont decision, the SJC has essentially said, yes, that scenario is a treble damage scenario. Even being paid 1 day or a few hours late is going to trip the triple damages button. So we are in a zero margin for error environment when it comes to payroll practices. Your payroll administrators just became both the most valuable and the most stressed out people in your building, whether they know it or not. And to illustrate the extent of the stringency around this set of requirements, you could be, so far as I read the Reuter decision, a victim of a crime. You could get hit with a cyber attack on your payroll date that keeps you from getting your payroll out in a timely way. And as a result, you're going to be on the hook for treble damages for your entire payroll that would have gone out that day. And the statute and the Reuter opinion provide no obvious defense to that sort of claim unless it would be on due process grounds, which is untested. We've got a bunch of theories that we've kicked around as to what the litigation of wage disputes may look like after Reuter, but there's a lot of uncertainty. And the one thing that is clear is that it is very dangerous out there for payroll practices. So the first thing that I think an employer concerned about this Reuter decision is going to want to do is scrutinize its payroll practice from stem to stern in terms of how time or other working data is entered into the system, where it enters into the payroll function, and every step along the way. When we're looking at our own processes for litigation, one thing we often do is process map those, break them down, get them written out, and identify any points of failure and any potential for delay that you see in that process. And I think there's a premium on doing that at this point, and build in for yourself, if you can, a little bit of wiggle room. If you can take your payroll process apart and put it back together in a way that even gives you 1 extra day to meet your obligations under the Wage Act to pay all wages within 6 days of the close of the pay period that you're satisfying, that's going to be a valuable day. It's a difficult task because 6 days is a quick turn, but I think a lot of employers are going to want to think about really going to lengths to do everything that they can in that regard. The second thing that's going to be absolutely critical is to review all of your compensation plans that govern what people are entitled to and when. And the biggest powder keg in this space is commission plans. Even before the Reuter decision came down, in our daily review of the cases that are filed in the Massachusetts courts, we would oftentimes see 2 of these a day, many a week, where you have a Superior Court lawsuit that's about nothing other than an employee seeking a commission payment. And it could be that the commission was paid late. It could be that there's a dispute about the amount of the commission. It could be any of those things. And when you litigate a lot of those disputes, as Molly and I have, you learn that the commission plans themselves are often not a model of clarity. And that is going to create exposure. It's not limited to commission plans. It could also be with bonus plans or any sort of incentive compensation. But I would encourage employers to open those plans up and make sure, 1, any ambiguity is scrubbed out to the maximum extent possible so you don't have disputes about what people are owed. And 2, that you have real clarity around when payments are going to be made. There again, commission plans are tricky because in Massachusetts, employees generally have to be paid biweekly if they're non-exempt, or up to monthly if they're exempt. And commissions are often paid on a delayed basis. And one thing the courts have yet to address is the relationship between the timing of payment requirements in the Wage Act and a commission plan. So if you've got a commission plan that pays commissions 1 month in arrears, you're going to need provisions in that plan that provides a basis for you to say, I could not have paid those commissions within 6 days of the close of the pay period in which they're due. And there are ways to do that. We've done it a number of different ways, but those timing of payment requirements are very likely going to be the subject of litigation going forward. A third tool that you may want to add to your toolkit is revising any procedures that your HR group is using around termination, or put in place procedures around the termination of employees, to give yourself a couple of different opportunities. One is suspending an employee rather than firing them on their last day. Curiously, the Reuter decision expressly acknowledges that as a solution to the problem that the Reuter decision creates. It says that, unfortunately, that may be what an employer has to do. Rather than terminate an employee on a given day, suspend them subject to further investigation or resolution of open issues. And then once you have all of your ducks in a row, certainly including the employee's final pay, implement a termination, which would have left the plaintiff in Reuter in exactly the same place she ended up if the city had suspended her rather than fired her. But under this new SJC case law, the outcome is radically different. The second thing you may want to do is ensure that if suspending employees is not an option, and that option, I should say, is complicated with respect to salaried employees who you may have to pay if you're in the middle of a work week and you're suspending someone subject to an investigation, or union employees, which in all fairness, the plaintiff in Reuter likely was. So it may not be so simple to suspend people, at least without pay. And where you can't do that, what you want to make sure you can do to the maximum extent practicable is get a check for all final wages out to somebody. And in some cases, that may include a protocol for cutting live checks to people who have to be terminated on short notice. So let's go to the next slide. I know that the news that we've given you so far has been good and uplifting, so we wanted to take a preview of future events that may sort of dim the rosy picture that we've painted for you so far. One of the truly remarkable things about the Reuter decision is that the only indication of any concern among the 7 justices on the SJC about this ruling was a concern that it may not go far enough, and that in addition to mandatory treble damages, plaintiffs might also be in a position to collect what we call consequential damages. So, for example, if an employee is paid late and had their mortgage payment set up on an automatic withdrawal, and the employer's late payment of wages causes the employee to miss the mortgage payment, and there are economic consequences for that, Justice Georges wrote separately to say, well, the employee might be able to recover for that in addition to the treble damages. And the full court declined to go down that road, but certainly didn't suggest that was not the case. The full court's response to that was, it wasn't presented here, it's not ripe, so we're not going to deal with it. But beware, the consequences of a late payment of wages could be even substantially greater than the treble damages that we're talking about. And if that weren't enough, we have some legislation pending in Massachusetts that would ratchet up a number of penalties that relate to the Wage Act. The new statute is cobbled together and touches many different points in Massachusetts wage and hour law, but we've got a statute that's now made it out of committee with a favorable report that would allow the Attorney General to issue stop work orders without prior judicial process in the event that she determines there's a wage violation. The statute also includes a private Attorney General component that would allow employees to bring claims essentially on behalf of the state and on behalf of groups of employees, even without a class action device. And we've got a presumption of retaliation built into the statute anytime an employer does anything after an employee raises any issues whatsoever about their pay. So the takeaway point is that the environment around wage payment in Massachusetts is pernicious, it's very dangerous, and you're going to need to revamp a lot of your procedures. One thing you need to do generally is make sure that you have a copy of the Massachusetts Peculiarities publication. There are a lot of traps in Massachusetts law, many statutes that are old and out of date, like the Wage Act itself. And we've digested that in Seyfarth Shaw's Mass Peculiarities publication for many years now. We have a version coming out in a week or so for 2022 that will capture the Reuter decision and lots of other updates to try and help keep you out of the way of this dangerous new set of statutes. And with that, I think we can allow Kate to read the CLE code.
Thank you for your participation in today's webinar. The CLE code is SS, as in Seyfarth Shaw, SS 3621. Again, that's SS 3621. Thank you, everyone, for attending.
Thank you.